application in the matter of Omooba and Michael Garrett Associates and another.
Yes, good morning, Mr. Petty.
Good morning, my lord. May it please you, my lordships, my ladyship, my lady, forgive me. I'm representing the appellant, Moylan friends, Mr. Coughlin, Queen Counsel for second respondent, and Mr. Milson for first respondent.
Yeah.
We've had our heads together about one particularly important housekeeping matter, which
Sorry,
is the division
you had...
of our heads together.
Yes.
Sorry, I'll speak up.
Yes, please.
Which is the division of time.
Yes.
And particularly how much we have available to us, whether your lordships, your ladyship plan to give a judgment today or to reserve.
I've no idea, but probably not a judgment today.
I'm grateful. We've agreed that, as one would expect, I will go first. I will not split up my submissions on the two separate matters, conscious that the test for reopening incorporates a but-for element on permission in any event. So I'll deal with each ground.
Sorry, what do you mean two matters? I thought there was one matter.
The rolled up, it's a rolled up permission to reopen and permission to appeal is what
You've got to get over the first hurdle first, Mr.
Yes,
Petty.
indeed. Yes, indeed. And
It's a very high hurdle indeed.
Yes.
Yeah. So you're going to have to persuade us that Lord Justice Bean failed to grapple with the issues in the case in the light of the Employment Tribunal, the very clear Employment Tribunal findings of fact. Yeah. So that's your task for today.
My lord, yes.
The rest will follow if you manage to attempt it.
Yes. I should say that I will address grounds 1 to 6. Mr. Quintavalli, who I should have mentioned earlier, will address the documents grounds 7 and 8.
Right. Well, I think, as I say, the key issue here is not bifurcating the case into small, tiny pieces. It is showing that Lord Justice Bean failed properly to address the application for permission to appeal when it was made to him. And if he didn't, then you don't get to first base on any of those grounds.
My lord, yes. I accept that, of course, although it does relate to each ground separately.
Well, it does and it doesn't. If he grappled with the case as a whole, it is not imperative in a permission to appeal application to set out in meticulous detail why ground 43C is as bad as the others if he's grappled with the main issues in the case. So we're not going to be descending into a massive amount of detail in a case which is quite a straightforward case and was dealt with at first instance and on appeal in meticulous detail by two courts, tribunals. So, Mr. Petto, you have got to identify something that is really seriously problematic to enable this decision by this court to be reopened. We do not encourage these applications. Right? I think you've read my judgment on the subject.
My lord, I have.
Yes, good. So what I don't want to do is to get into a lot of pettifogging detail, which is to obfuscate rather than elucidate. You need to show me that the judge who dealt with it didn't grapple with the case. Okay, so I just want that to be a little bit of a clear statement of where we're going here. This is a 5230 application and really nothing else. The rolled up bit only happens if you get over the 5230.
I'm grateful, my lord.
Now, how long are you proposing to speak for?
Well, we had divided up the day on the basis that essentially the morning would belong to the appellant.
Right, well, that sounds very sensible. You happy with that?
Yes, ma'am.
Good, okay, on you go, Mr. Petto. We'll try and let you do it.
My lord, the most obvious example of a failure to grapple in our submission is on grounds 1 and 2. Those cover what the President of the Employment Appeal Tribunal described as the crucial liability issue in the case. That is to say, was Miss Omooba's detrimental treatment by the two respondents because of her protected beliefs or their expression. I have your Lordship's indication ringing in my ears. I will come very swiftly to Lord Justice Bean's reasons for refusal on those grounds. I do wish to invite the court to stand back first. The findings of the tribunal, the Employment Tribunal challenged by Miss Omooba are, in respect of her agent, who dropped her from its books, that when it did so, because of the anticipated adverse effect on its business of her protected beliefs, considering the potential reaction and some actual reactions of his staff and clients.
I'm sorry.
That
where do you get that formulation of words, because of the effect on our business, because of her beliefs?
My Lord, that is the inevitable consequence of the tribunal's findings of fact.
Right, show me the finding of fact that says that.
In the permission to appeal bundle, my Lord, the core bundle.
Well, there are 3 bundles that I'm calling core, and they all seem to be different and have different numbering. Is it the one with the Lord Justice Bean decision, or is it the other one?
It is the other one, my Lord.
Yes. Okay. Got it. Tab 6, right?
Yes, the tribunal's judgment appears at page 148.
Sorry, the tribunal's judgment of 148, yes.
On liability.
Yes, exactly.
And the section dealing with direct discrimination by the first respondent, the appellant's agent, is at paragraph 1110.
110.
Yes, 110, sorry. Going through to about 112.
Yes.
At page 168, if your lordships, your ladyship are content to dive in to the middle of the paragraph,
Yes.
about 5 lines down from the top of page 168, maybe 6, a sentence begins, the agency. The agency had to consider the extent to which other clients would dislike the association with the claimant and whether they'd be damaged by association. The claimant had made her view public and had not stood by it when it attracted adverse comment. That the not is, by agreement of all, anomalous. It should be ignored. So she made her view public and stood by it when it attracted adverse comment. So the finding there, and it echoes further down, as we will see, is that the agency was motivated by the extent to which other clients would dislike the association with the claimant, or because of what she believed, what had been made known about her protected beliefs. And that she'd made her view public and stood by it. And then dropping down to the bottom of that paragraph, he, that's Mr. Garrett of the first respondent, had also to consider the effect of representing her on the agency's reputation and the effect on that on supply of work, so effect on business. And then at 112, the first sentence in my submission could not be clearer. On the evidence, he terminated the contract because he thought a continued association would damage the business. Again, association with
But what about the second sentence? The contract was not terminated because of her religious belief, but because in his mind the publicity storm about her part in the colour purple threatened the agency's survival. Is that not the determinative finding?
That's the conclusion to which the tribunal comes.
Well, that may
And
be
it
the
is
same
wrong.
thing, mayn't it, Mr. Pettit?
But that's the appeal on those grounds, my lord. That conclusion, in respect of both respondents, is wrong. It's wrong as a matter of principle, and I will take you to the statement of principle.
That's
Because-
not really the issue for us as to whether it's wrong as a matter of principle. The issue for us is whether Lord Justice Bean failed to grapple with this being the ground of appeal.
Yes, and in my submission, that is precisely what happened, my lord.
Right.
So that is for respondent 1. And the holding of the tribunal, because this is a direct discrimination claim, is that the dropping of the appellant from its books by the agent was in no part because of her protected beliefs. That's the effect of discrimination, was that there need only be a material contribution, as it were, of the protected characteristic in the relevant treatment. And for the theatre, similar findings, similarly in my submission, are obviously wrong conclusion from those findings. And I appreciate that that is not the issue before you, but it is necessary to go via that
Yes, show us where.
that point to Lord Justice Bean's comments and reasons. If you still have it open, my lord, it is paragraph 107, so a little further back. Here the tribunal is reaching its conclusions about the second respondent's treatment of the appellant.
It's the last two sentences.
That is the conclusion, yes. And in our submission, that which precedes it by way of factual findings runs directly contrary to it. It is a clear statement of facts that must be concluded to amount to direct discrimination on grounds of the appellant's beliefs.
Sorry, when you say the last sentences of the conclusion, are they not findings? You've referred to them as findings or concluded. Are they not, similarly with paragraph 112, are they not the Employment Tribunal's findings as to the reasons why the contract was terminated and in respect of the agency and in respect of the theatre?
My lord, well, they all are.
Findings.
They all are findings.
Right.
And so the ultimate finding, which I've described as the conclusion because it is said to be the end point of the others, is entirely inconsistent with the other findings. And that is a matter of principle. It's a matter of principle with which Lord Justice Bean agreed in this court in Higgs.
Sorry, that's too compressed for me. I don't understand the submission. Can you say it again in a less compressed form?
Yes. Where, as here, an employer treats an employee who's expressed protected beliefs, or holds protected beliefs, detrimentally because of the reputational effect or third parties' actual or potential discriminatory responses to those beliefs, it is discriminating against that employee on grounds of those beliefs.
Yes, that's not what you said a minute ago.
I'd hope that it was, my lord. I'm sorry that it wasn't clear.
Okay.
That is the point of principle.
Sorry, that's a submission of law, and these are findings, and you're saying the findings are wrong.
That the conclusion is wrong in law.
The decision to terminate was to deal that the contract was terminated because those are findings. How can those findings be inconsistent with the principle of law?
Well, that is, forgive me, my lord, I may not have understood your question, but that is the conclusion to which we say one is driven by the application of that principle of law, that matter of principle, to the findings made in, among other places, this paragraph, barring the last. The last is a conclusion that is wrong in law.
And I think we're all sailing like ships in the night. This is a factual finding. It is factually found by the tribunal that the belief of your client was not the reason why the theatre decided to terminate her. It was the commercial and artistic reality of the cluster of factors that it would not succeed. In other words, this is about the theatre, that the production would not succeed. Now that's a finding of fact. The principle of law that you contend for is where an employer treats an employee with protective belief detrimentally because of third parties' responses to those beliefs. It's discriminating. But they have found that they were not treating her unfavourably because of third parties' responses to those beliefs. They were treating her as they did because of the dysfunctional situation that arose from the context and circumstances of the public retweeting, and her belief was not the reason why they decided to terminate her part. So, I mean, you have to grapple. You have to grapple with the fact that you've got that adverse finding of fact. I mean, that's what Mrs. Justice Eadie said as well, isn't it?
She upheld the conclusion of the tribunal.
Yes, but she explained the reason motive thing.
Yes. My lord, staying with paragraph 107 for a moment, and then I will go to the point of principle.
Mm-hmm.
The thrust of these grounds, 1 and 2, is that all through paragraph 107, until one gets to the conclusion,
Mm-hmm.
what the tribunal is finding, and it is impossible to see it any other way, is that the second respondent in this case was motivated by third-party discriminatory reaction. It is a list of examples of precisely that. The adverse publicity was people responding to the content of the Facebook post, the claimant's beliefs. The failure to modify or explain, as it's put, without modification or explanation, didn't mollify that response. The cohesion of the cast, again, responding to the claimant's beliefs. The audience's reception, again, the same. The reputation of the producers. The good standing and commercial success of the production. The reason why is the claimant's protected beliefs. And they say precisely those were the reasons why she was dismissed, third-party reactions to her beliefs. And they go still further and say the centrality of authentic depiction of a lesbian role was a key part of the factual matrix. it was not necessary that she should be a lesbian, but it was important that she was not perceived by audience and company as hostile to lesbians. Again, a perception, a discriminatory perception, based on her expressed belief.
Well, what was it important to?
My Lord, if I've understood the question correctly, that the tribunal is itself saying that these were the reasons why she was dismissed.
No. What was it important to when they say it was important that she was not hostile to lesbians? It was important she was not hostile to lesbians to the success of the production. Right?
Well, what the tribunal is discussing there is the depiction of the role. But the two go together.
Yes.
I don't shy away from that.
No.
The two go together.
And what the tribunal is saying is that a dysfunctional situation had arisen. It was important to the success of the production that she was not seen as hostile to lesbians. The religious belief, her hostility to lesbians, if that's what the religious belief was, let's for the sake of argument assume it was not the reason why the theatre decided to terminate her. It was the commercial and artistic reality that it wouldn't succeed, namely the production could not succeed with her continuing to express that hostility, which she had decided to do. And they say very clearly that the belief which is protected was not the reason they terminated her. Now, you may say, well, they should have decided something else, but
Well, that is the thrust of the ground. That if one, it's perhaps easier to substitute a different protected characteristic because it comes out very clearly.
mm-hmm.
If she were cast in a different production,
Mm-hmm.
in a white role as a black person,
Mm-hmm.
and she was dismissed because there was a faction of potential audience or a response that was hostile to the fact that she'd been cast in that role as someone who wasn't white, then
Well, what if nobody was going to take your example and nobody was ever going to come? I mean, actually, the reverse is true. It seems to be very popular now. But let's assume that nobody would ever come to such a casting, a production with such a casting, right? And the theatre decides that they cannot proceed with it, with such a casting, so they terminate because it's economically unviable. You say that's discrimination.
yes, that is discrimination because
Well, that works against that works in favour of more discrimination, doesn't it? Because it means nobody would ever be cast in such roles.
well, my lord, the position purely and simply on this side of the courtroom is that that is the law. That's the law as expressed by the President of the Employment Appeal Tribunal in Higgs,
Right.
and it's the law as expressed by this court in Higgs.
Right. Okay.
I mean, put it another way, you're saying that I think you're having to say that the only conclusion open to the tribunal was that the reason why was discrimination. Why, can we just explore why that is the only conclusion you say is open?
Well, on the findings it made, of course.
Well,
So
but those findings include, critically, the commercial impact, that the reality that the production would not succeed, and in the case of the first respondent, the threat to its survival. Where do you put those factors? Are they argument seems to require them to be put to one side, or factors that the tribunal really can't treat as affecting its conclusion, because I think you have to say there is only one conclusion it could have reached.
Yes. And that is because the law prioritises the prohibition of direct discrimination over commercial interests. So,
Well, I haven't. You'll have to show us where that is shown to be the case, because no one seems to be disputing that the right approach is to determine the reason why, and that is in principle a factual determination. So what trammels that in a way that you say it must do to require, in this case, finding of discrimination?
I want to be careful that I've understood your question, your lady, m'lady. Tell me if this isn't an answer to it.
Yeah.
On this tribunal's findings, in 107 or 110, 112, depending on the respondent, what is driving the treatment is the effect of the claimant's beliefs on the minds of others. It's not a background matter. It's the motivation. And so that is direct discrimination. It is, in all material senses, identical to discrimination on grounds of where there is a reputational impact, as dealt with in Higgs. It may help if I go to the relevant statement in the summary in Higgs. By way
It
of
may, but you also had to persuade me that Higgs has got really anything to do with this, the point we're discussing now.
Well, my lady, may I
we have a look at Higgs,
Yeah.
and then we can consider.
The relevant paragraph is 175 in the Court of Appeals in Lord Justice Underhill's judgment.
Yes. Yeah.
And the relevance of Higgs,
Well, what are you?
At least
which
for our
bit of
purposes.
Higgs are you reading?
Yes, which part of the summary are we looking at?
it's 1752 particularly,
Two,
from which I draw
thank
the
you.
statement of principle.
Well, indeed, but that's what Higgs was all about, which was
Oh, I'm sorry.
objectionable manner of
Forgive me. It's my highlighting that's misled me. It's 1751. I apologise.
1751, okay. So I've just paused to say that 1752 was what the heart of Higgs was about.
Yes, yes. And of course I accept that. But Higgs recapitulates the law
Yes.
in this area.
Right.
That is what is happening at paragraph 175. And
Yes.
1751,
Well, as with all summaries, you have to take care, but it does say the word merely. What do you say to that?
well, that is what is happening here. It is merely because, or simply because, of the effect on the minds of others of the claimant's beliefs. that is the commercial risk. That is the reputational risk or damage. And third parties would, in my submission, clearly include other employees, here cast members or other clients of the agent.
Well, I mean, you seem to extrapolate from a quite simple summary, which says the dismissal of an employee merely because they've expressed a protected belief to which third parties, to summarise, object, will be unlawful discrimination. But this is not merely because they've expressed a belief to which third parties object. This is because the effect of her having expressed that belief is that the production is unviable. Right?
Well, the production, the commercial success of the production is undermined, certainly.
Well, I mean, they found it was not viable with her in the role. So, but I mean, it doesn't matter the words you use. The finding of fact in the paragraphs 107 and 110 and 112 is that economically it's impossible to do it with her, and that the reason, therefore, was the economic reason, and not merely because she'd expressed the view. So you're passing like ships in the night with the other side here.
Well, my lord, if I may take you to a further summary, not a summary, it's a statement of...
Yes, well, let's go to other bits of Higgs if you say they help you more.
If I may take you to the Employment Appeal Tribunal in Higgs, to the President of the Employment Appeal Tribunal's judgment.
Okay,
in
well,
that
wasn't
case.
upheld, was it?
Parts of it were upheld.
Parts of it were, yes, but we have to know which bits.
Well, it is as it were, the forerunner of the paragraph to which I've just taken you in the Court of Appeal.
For my part, I would be it would help to go to where the Court of Appeal in Higgs, Lord Justice Underhill to be accurate, actually dealt in longhand, as it were, with the point that's summarised in 1751. Then we can go to the EAT as appropriate, because not everything said by the EAT was approved.
No, and it's right also that the reasoning of the Court of Appeal has this point picked up and attributed to submissions as the judgment of Lord Justice Underhill addresses those submissions. So that particular point is encapsulated in a paragraph that is part of the judgment without that feature, as it were.
Sorry, I'm not sure I follow that. Can you take us to is it the separability part of which part of it of Higgs is summarised in 1751?
One element we find in paragraph 138.
138, thank you.
Yeah.
So 138, and this is what I was driving at earlier, milady. The Lord Justice Underhill is dealing with a submission by Mr. O'Dare for the claimant, for the appellant in the Higgs case. And you'll see 5 lines down, he submitted that reliance on reputational damage of the nature in that case was unacceptable in principle. And he goes on, it's part of the price of a pluralist society but employers may sometimes have to take a hit for employing someone who expresses unpopular beliefs. It's well established that an employer can't avoid liability for race or sex discrimination by showing that the act complained of was done in order to avoid adverse reactions from racist or sexist customers or clients. And the case of Din is given as an example. And then at 139, what Lord Justice Underhill says is the ET was not addressing the issue of justification as such. I'm not sure that the effect of its reasoning is indeed as Mr. O'Dare characterised it, but I agree with him that if it is wrong in principle.
Well, then he goes on.
With the word simply. And the sentence, nor does the employee have carte blanche. The characteristics of the employment relationship may entitle the employer to pose limitations. The particular characteristic with which we are concerned is the employer's legitimate interest in protecting its reputation, not only with customers but also with other third parties, including other employees. The extent that it be justified will depend on the circumstances. It's not possible to give any kind of general exposition. So all that tells you is that it's a matter of fact and degree, and it may well be justified. It may well be appropriate for the employer to protect its economic position.
Well, my lord, there are two separate matters being addressed in my submission in that paragraph.
Well, yes, and most of it, if I may say, is about the whole question of objective justification, which is not
indirect
not
discrimination.
what this case, well, not what this challenge in this case is about.
What is said in 138 and the first part of 139 in my submission is not restricted in that way. So what is said there simply is, it's halfway down 138, an employer cannot avoid liability for race or sex discrimination by showing that it was done to avoid adverse reactions from racist or sexist customers or clients.
I mean, obviously Din and Carrington exists, and no doubt the tribunals were well aware of it. You have to read it in the context of what Lord Justice Underhill actually says in response to those submissions.
Yes, and so when we come to 139, what Lord Justice Underhill is addressing when he deals with what the employee is not allowed to do is what I've termed in my submissions objectionable manifestation. So, not this case.
It is not this case.
No.
What this case is about, is it not? Or at least what you need to attack is the so-called separability approach, whatever label you might apply to it, which is referred to elsewhere in the judgment by reference to Lady Justice Simler's decision in Kong.
Yes, to which I will come, but reading this with the summary, we see where the two stages are echoed in these paragraphs. So feeding this through to the summary, and this is the best and clearest section of the judgment corresponding with the summary. What is happening in the summary section is that Lord Justice Underhill is dealing with that point first, and then moving on to
The problem with this is
justification.
that he's actually dealing with Mr. Adair's submissions. That's what he's doing. He's setting them out and making some comments as he goes along. This is not the decision-making passage of the judgment.
No.
So can we look at the decision-making passage of the judgment?
Well, this is where that is 175, 1 and 2. We see the echo of Lord Justice Underhill's agreement with the submission for the claimant at 139. And indeed at 139,
I
Lord
think
Justice...
it's under the heading discussion and conclusion.
Yes.
156. Follows from my observations on his submissions that there's no threshold objection to the school's case on justification. It's not what we're dealing with here.
Yes, that was the matter for appeal in Higgs.
Yes,
And
different case.
I fully appreciate that, and indeed Lord Justice Underhill states that the guidance he is giving is obiter because Page is binding on the court. But it is this court setting out the law in this area, clarifying the law in this area, not purporting to change it, of course. And that is what, in our submission, Lord Justice Bean failed to take into account altogether, failed to grapple with altogether when addressing these grounds. That this is that sort of case. It is a particularly striking example on its facts of an employer, as in Din, please tell me if I should take your lordship's relationship to Din.
You have to go to any case you need to go to make your case. We can't tell you what to go to.
I probably ought to in that case, but let me at least summarise it. In Din, an employer refused to welcome a foreign employee back, where there was an understanding that this employer would do that after a trip away. Because there had been a contretemps with his manager, which the tribunal in that case found had been racially motivated, that the manager's conduct had been racially motivated. And there had at the time been a reaction within the workforce to that incident. Now, on the basis of those findings, the matter was remitted for more detailed findings to be made, but on the basis of those findings, were they to be made, Lord Justice Brown-Wilkinson found that that would be direct discrimination on grounds of race, the refusal to welcome him back. Because of the employer's reliance on the workforce reaction. Now, it was in the commercial interests of the employer not to welcome the employee back, not to take him on again.
Yes, but was there a finding in that case that they were motivated not by the discrimination, not by the belief, but by only their commercial interests? I'm not sure it gets into that level of detail. But that's the important thing to get into, because here we're dealing with a very specific case. We're dealing with a very unusual case which put the respondents in a very difficult position. There was an unfortunate retweeting, nobody's fault, followed by a whole series of interactions about draft statements, and the respondents were then put in the position that they had to decide what to do about all that, including the appellant put out a retraction as such, but to only say some things, and the respondents' desire to retain their business. And all that was played out in meticulous detail before the Employment Tribunal. And the Employment Tribunal held that the reason why they acted as they did was motivated entirely by their desire to retain their business. And it's all very well to say, well, you have to take a hit sometimes, but if the hit is your entire business being destroyed, then can it really be said that you're motivated merely by the third party's reaction to the employee's belief? Perhaps not. And that seems to be what the Employment Tribunal decided here.
But even if that were the case, my lord,
Well, that is the case. That's what they decided.
they have also found that both the theatre employing and the agent are motivated by, that their reasons include the third party reaction to the appellant's beliefs.
Well, I'm not sure that's how they put the findings. I mean, we have your point, but I think you accept these are findings of fact, as I understand it. But you have to say that the Employment Tribunal committed an error of law in that they were bound to reach a different conclusion, and that, I'm afraid, I'm still struggling with. It's common ground, it's uncontroversial that you can't simply hide behind, if you like, a third party's discriminatory views or behaviour. But surely the challenge you need to meet is that the Employment Tribunal found it wasn't just that, it was something much more fundamental, threats to their business.
Yes, the point I was making a moment ago stands in my submission, which is that even if it is right that one can separate those two out, the tribunal's own findings are that both respondents are motivated by the association with claimant's beliefs and the third party response to it, be it other clients on the agent's books, staff members.
Well, I think we're going round in circles. We understand that that's what they found as a step in their reasoning. But they said that their ultimate decision was, effectively, that the respondents had no choice if they wanted to stay in business. And they said that means that the test of whether they were merely motivated by the reaction of third parties to the employer's belief was satisfied, and they said no. And you are saying that basically employers must accept in such a situation the collapse of their business in order to comply with the law. That's your submission, as I understand it. And that's fine. I mean, I accept that's your submission, and we will have to deal with it. But it's very stark, and I understand it now. You say that's the law, that's neither here nor there what their commercial position may be, because it's brought about by what happened, which in this case is very stark. For my part, I think now we have to look at Lord Justice Bean, because you say he failed to grapple with Higgs, but Higgs doesn't seem to me to say what you're really submitting.
My lord, yes. I should say that I don't stand back completely from the proposition, from your repeating of my submissions. But
Well, I'm putting it in what I would consider an intelligible format, which is that this situation was very tough, but the very tough situation means that they had no choice but to proceed, and they were not permitted, without breaking the law, to sack her. That's it.
My lord, essentially that is it. In this sense, if I may put it this way, and I will come to Lord Justice Bean, that it is not permissible to treat someone detrimentally because of their beliefs or any other protected characteristic, simply because it's bad for your business to do otherwise.
Okay?
And the answer is that there are defences to direct discrimination. There are narrow defences. That is the way the law is set up. And it is conceivable, barring the intervention of Parliament, that a business might choose to commit the tort and compensate rather than take the commercial risk. But that is the balance of the law. Direct discrimination, the protection of people from direct discrimination on grounds of their protected characteristics, whatever they may be, comes before commercial interest. Here there was a defence that was sought to be run of occupational requirement under Schedule 9. The tribunal didn't get to it ultimately, because we didn't cross the discrimination hurdle. That is the real battleground of my submission of this case.
Well, only the battleground if you're right in your submissions you've just made, right?
Yes.
Yeah.
My Lords, my Lady, I should take you to Lord Justice Bean at page 3 of the Permission to Reopen bundle.
Is it helpful to see what he was responding to, in other words, to the way the grounds were structured?
Yes, that is the bundle we were in a moment ago, my Lord, the Permission to Appeal bundle, at page 16.
Yeah. Yeah. Page 60.
16 is the grounds, my Lord, yes, in the Permission to Appeal bundle.
Well, my page 16 looks like has a heading, the Higgs case. Is that right?
I think we're in the wrong bundle. It says PTA core bundle.
It's the original bundle.
Okay. Very confusing that we don't have the normal bundles here. I've got the grounds of appeal. Yeah.
Yes, my Lord.
Okay.
And it's 1 and 2, direct discrimination.
What would you say was the essence of your ground 1?
That the tribunal treated the respondent's motive to protect their business wrongly as the reason why they dismissed the claimant.
So in the second sentence, it's you focus on operative reasons. and your challenge is contending that the Employment Tribunal's findings were demonstrably, or they misdirected themselves because they, as my lady was pointing out before, your submission was that they were compelled to conclude that the appellant's protective beliefs and or their manifestation were operative reasons.
Yes.
So was the main challenge to the issue of operative reasons for the less favourable treatment? Is that a better way of describing or analysing ground one?
Well, without the definite article, possibly. Because they need only be operative reasons. They need only be material
Yes.
reasons. But the point is that this is a matter of law. It's an error of law to get this wrong, to fail to distinguish between reasons and motives. And both respondents had a business motive. But the findings of the tribunal are that they were motivated by the reason why they were acting
Yeah.
was because of the claimant's beliefs.
I mean, it's not difficult actually. I think. I mean, this is reasonably opaque, paragraph 1. But what you're saying is that they misdirected themselves. That it was possible to find that the reason was the commercial consideration, when the commercial consideration was caused by the public reaction to her beliefs, and that the only choice they had as a matter of law was to find that that was an operative reason for their decision.
My Lord,
That
I
is
agree.
what you say, and if
Yes.
you're right, you're right. Let's look at Lord Justice Bean, shall we, or do you want to look at 2?
Let's take them one at a time, my Lord, if we may.
Okay, then let's go back to Lord Justice Bean. The other bundle. And he said the reason why issue was a question of fact for the Employment Tribunal. Like the President of the EAT, I'm satisfied the ET reached permissible conclusions as to the reasons why the claimant was dismissed and had her contract terminated, and were entitled to find that the religious beliefs and manifestations were not operative reasons. So he entirely grappled with your point, but he said he didn't agree with it. And the question is your point right? But even if it's right, it's not that he failed to grapple with it, it's simply that he didn't agree with it. So it's been dealt with, and the fact that it's wrong is not a 5230, is not conclusive on 5230.
My Lord, before I grapple with that, may I ask you to look
There'll
at
be a
what
lot
I'm
of
saying?
grappling this
An
morning.
awful lot. May I ask you to look at the way it was expressed in my skeleton argument?
Of course.
It's page 22
Of the skeleton.
Permission to Appeal bundle, so just a few pages after the grounds.
Yes. Paragraph 33.
Oh no, you should be in paragraph 4 at the bottom of page 22.
Yeah. Yes. Yes. Was it on grounds of race, or was it for some other reason, for instance, because the plaintiff was not so well qualified for the job? Yeah?
Indeed.
It also indicates, as you expect, that involves a subjective, that is, requires subjective determination of what was in the mind of the decision maker.
Yes. Yes, it does. And that would include what in Ahmed the Court of Appeal called a criterion. I'll need to come to it.
Yeah.
That is to say, it need not necessarily be an animus against a person for their protected characteristic. It may be a criterion, such as we need someone in this role who doesn't have these beliefs.
Right, where are we going now?
My Lord, have you kindly read through to the end of 13?
Yes.
I'm grateful. What Lord Justice Bean has not grappled with is that there's nothing to indicate that any of those submissions has been taken into account. They deal with what the EAT and the ET did to get to their conclusions and explain why that was wrong in law. For example, at 8, that there was no direction to distinguish reason from motive at all, and that there were findings that showed, as we discussed, that an operative reason was the view that the appellant's publicly expressed beliefs were damaging to business. In that passage, I have compared this case with the Ahmed case, to which I will need to take you.
With the which case?
The Ahmed case, paragraph 9, my Lord, top of page 24.
Amnesty. Yeah, let's call it amnesty, yeah.
Yes.
Yes.
And with the Din case, and none of that has been grappled with. The point being that on this tribunal's findings, there is a reason there which is discriminatory. A motive has been clearly stated. There was a business motive. But there's also reason for acting.
Well, how did Mrs. Justice Eady deal with it? I mean, this is the critical point, isn't it?
Well, it is, and the sentence in that judgment, the EAT judgment, is essentially what we see in Lord Justice Bean's point 1.
Sorry, there's a sentence in the EAT judgment.
The relevant sentence in the President's judgment, in Mrs. Justice Eady's judgment, essentially says that that is not what the tribunal found.
Which paragraph?
It will be around 155, my Lord. I'll if I go in there, I'll be able to get you to it quickly.
My Lady, it's paragraphs 155 onwards, page 101 of the Court.
I'm grateful.
Yeah, that's right. She said, simply not what the ET found,
Yes,
which is effectively what Lord Justice Bean said.
yes.
And this is addressing the reason motive submission, which was made to the EAT.
Yes, it is.
So, how do you say that Lord Justice Bean didn't, well, you said there was no indication that he was say, aware of it or deal with it, but it's identified in the EAT's decision.
Yes, my point is that the criticism that's made, the issue that is raised by the ground of appeal, is not grappled with. Which is that, yes, that is something the tribunal found, but it's not all the tribunal found. The tribunal made findings about the reasons why the respondents acted.
Well,
And those...
yeah, I mean, if you're right, you're right. I mean, this is quite a simple case.
Yes.
Nobody is doubting that on the road to finding that they were motivated entirely by commercial considerations, they had regard and had to have regard to the fact that she had a belief she wouldn't change, and that was causing third parties to have an adverse reaction to their production and her. And so if you're right that compels the conclusion, as in amnesty, that it didn't matter that it was very sensible, for example, for the employee not to go to Sudan or whatever the country was, but it compelled the conclusion that there had been direct discrimination against her because that was part of the reasoning, then you're right. And he didn't grapple with that point because he thought it was wrong. and I mean, maybe then we do get to a situation where, when we've decided you're right, we have to decide whether being flat wrong is a ground for reopening in this case, which will depend 5230 provisions and the authorities. But is there anything more you want to say about why he was flat wrong? Because it does strike me as a very binary argument. I mean, it's easy to understand, so I don't deprecate it on that ground, which sometimes I do. But is there any more authority? Because she deals, Mrs. Justice Eadie, with DIN and says it's not relevant, right? Not analogous. But you say it is still, do you?
Yes, I say it's important, and I'll take you to it. But just on the subject of right and wrong, I might ultimately be wrong, of course, but I'm here arguing for the opportunity to argue it.
Yes.
And what I say is that Lord Justice Bean hasn't addressed what I've said at all.
Well, he sort of did. He said it's not what they found. But I mean, the question is maybe a slightly more obtuse one, which is that he's right, but if the legal question that lies behind it that you've raised in your paragraphs 5 to 13 are correct, then the fact that it's not what the tribunal found is not an answer.
Quite so. And hence I say it's not been grappled with. May I take you please to Appellant first of all.
Which page?
I apologise, I'm off-piste, so I'm just catching up with my notes.
That's part of our charm, Mr. Petto. Take advocates off-piste.
I'm grateful for your patience. 311 in the authorities bundle.
311. Yeah, got it.
I'm pausing. It may make sense if I invite you to read the head note, and then we can plunge in.
Yeah.
My apologies.
Where do you want to go in the judgment?
Page 329, please.
Yeah.
And B and C, chiefly C. Should be page 1468, where the tram lines are.
Yes. I mean, this is developed a bit later, where it's a question of whether it's the reason or a reason.
Yes. And of course, it need only be a reason, the protected characteristic. That discussion that your Lordship has in mind may be what follows almost directly, bottom of the page, bottom half of the page, and you'll see the thicker tram lines of My Learned Friends, where the court seeks to consider and reconcile the cases of James and Khan. James, the gender criterion for a swimming pool, which had a detrimental effect because of differing pension ages. And Khan, from which I think Milady Justice Falk took the expression mental processes. And one sees at 33 the different potential grounds or reasons considered by the court. "34 mental processes where one might place animus. And 35, the James sort of case.
Well, that's the distinction between motive and discrimination, motive and reason, yeah?
No, those are the
At 34.
those are two ways of approaching reason. So the motive in that was the first passage I took you to. Really, the motive in Amnesty International was what might be described as innocent, was among other things the claimant's safety because of how she'd be perceived because of her race. But the reason why she wasn't given the role was her race. Or it was at least a reason, an operative reason.
Yeah.
And that is what I say the tribunal failed to do here. The respondents had motives, commercial motives, reputational motives. That doesn't change the fact that the reason they were acting, or an operative reason, was the claimant's beliefs, that she held those beliefs, had expressed those beliefs, and wouldn't recant or modify those beliefs.
Yeah.
It's a sort of criterion reason, the sort that's described at paragraph 34. Sorry, 35.
Yeah.
As I say, essentially the criterion being, I won't have on my books someone who's expressed those beliefs. or in our production. So we submitted that this case is in that way like Ahmed. Obviously no cases are identical. And it wasn't grappled with at all.
So you say this is the so-called criterion case. You think this is closest to that?
Yes, I do. The tribunal did find that there was no hostility or animus against the claimant by the relevant decision makers because of her beliefs. But that's beside the point. They were effectively acting on the basis that they couldn't have someone with those expressed beliefs on the books or in the production, depending on the respondent. Or wouldn't.
So if they just let the production fail, I would have been all right, or waited for her to resign.
Yes, they wouldn't have discriminated. Yes.
Yeah.
And I should say something about that en passant.
So why was Mrs. Justice Eady wrong? She said the claimant seeks to compare this case to Din on JFS. In contrast, I'm reading at 156.
Thank you.
In contrast to the position in Din, the ET in the present proceeding didn't fail to engage with the background and ask whether prohibited discrimination by others would significantly influence the mental processes. On the contrary, carefully examine the background before determining that the claimant's belief was not an operative part of the reasoning. You say operative parts of reasoning is irrelevant.
Yes. That the tribunal has made findings about operative parts of the reasoning that are the claimant's protected beliefs. They are discriminatory.
And no amount of saying that they weren't matters.
Well, if one says they weren't, it's wrong because it's plain on the face of the page that what I've described as the conclusion in the paragraphs, I think it was 107 and 112, can't be taken in isolation without the findings that come before. Findings which include whilst it wasn't necessary for the claimant to be a lesbian, it was important that she wasn't perceived as hostile to lesbians. A criterion. Belief-based.
Okay.
I should move to the case of Din. It's the second authority in the bundle, page 87 in the authorities bundle.
Yeah.
I gave a précis of the facts earlier on.
Yes.
They're at page 88 and 89, bottom of 88, top of 89.
Yes.
And then page 90, letters D and E, please.
That's where motive and reason comes from.
Yes, and the associated paragraph of my skeleton argument, the associated argument, I should say, I don't refer specifically to the case in that part, is paragraph 11 at page 24 of the PTA bundle. Where I asked why the claimant was singled out. And it illustrates well the point in my submission. It corresponds with what Mr. Justice Brown-Wilkinson, as he then was, says about the decision involving a distinction between, for example, coloured and white employees. Well, here there is what the tribunal described as a dysfunctional situation. There's a commercial risk. In answer to that, the respondents take action. And they select the claimant to be dismissed. The reason for that is because she's the one who's expressed the protected belief. The motive is commercial.
And you raised this point before the European Court of Human Rights, and they rejected it.
We did, and I have an answer to the submissions that learned from Mr. Milson has prepared by reference to Ulla. Mm-hmm. It is, of course, right that under the Human Rights Act, the court is not expected or permitted to go beyond protection of the European Convention. But here the court is applying the Equality Act. Domestic law derived from EU law. One stark example of the difference being that direct discrimination is not justifiable under the Equality Act, but it is at Strasbourg. Strasbourg is supervising the UK's legislation and its compliance with the Convention. Our domestic courts are enforcing anti-discrimination legislation.
So you say Equality Act is stronger than European legal principle?
Simply that nothing is to be gained from pointing out that the Strasbourg court did not accept the claimant's petition. It isn't relevant to this exercise. And indeed our reluctance to provide the submission was simply because we wanted to keep costs down. There wasn't any reluctance for the respondents to see it.
Yes.
My Lord, one last passage in Din.
Yeah.
It's at page 91 of the bundle.
Yes.
D and F particularly.
Yes.
And that case was sent back for rehearing because the Employment Appeal Tribunal was not satisfied that the Industrial Tribunal had properly, or that its finding was sustainable, because they'd used the word motive.
Yes, it was the lack of detail on the finding that the manager had been racially motivated in the contretemps.
So it had to go back for a finding as to what the reason was for what had happened.
Yes, whether there had indeed been a racial motivation.
It wasn't saying it was not
contretemps.
open to the tribunal to find that. It was open, remained open to the tribunal to find that there was a reason which did not amount to discriminatory behaviour.
The tribunal had found that it was racially motivated, but it put no detail with that finding. Hence my hesitation, my lord.
I think my lord's point here is that the tribunal was emphasising that the question of reason was a factual question. But you are saying that it's well, I mean, I see what you're saying. You're saying you simply can't have a situation in which the circumstances disclose what they disclose here, which is that what happened happened. They found facts. And then you conclude that the real reason, the only operative reason, was commercial.
Yes.
But that's never actually been decided in those terms, has it? On the question of the factual determinations.
Whether
That in such a situation, there is only one option for the court, which is what you say. I mean, you've said it very clearly, Mr. Fetto, so I understand it. And if you're, as I keep on saying, if you're right, you're right. And you can hear from the tone of voice that I'm not entirely yet convinced that you are right. But some of these cases, in somewhat different era, would indicate, subject to my Lord's point, that you are right. But my Lord's point is, well, this is what they all say is it's all about fact, and the tribunal has to make a finding of fact, and if it makes a finding of fact, it's not violable. They hadn't done the right finding because of the lovely distinction between motive and reason, which I have to tell you I find completely opaque, personally. But since I'm told by none other than Lord Justice or Lord Brown Wilkinson that that's the distinction, I'm prepared to accept it for the purposes of this argument. But I would love to see a more modern case that made this point starkly in support of you, rather than the old-fashioned ET cases or EAT cases. But maybe there isn't one.
Well, there are.
I mean, amnesty is as close as you get, really.
Amnesty is certainly a modern example. But the bottom line is that whenever an employer is treating someone detrimentally for reputational reasons, it's commercial. And
well, yes, but I mean that sort of elides my problem, doesn't it? I mean, of course that's right, but one can have different scales of commercial consequence. So here was found by the tribunal that the agency's entire existence was at risk, and obviously the production of this play was at risk for the theatre. You know, you can say, well, you should have promoted a person to a particular position, notwithstanding the problems. You can say that you should have not dismissed an employee who was causing the kind of trouble in Din. I get the names confused, but I hope I'm right. Which is sort of one thing, but I suppose Din is quite close if it is Din we're looking at. Yeah, Din is quite close to this because it was causing wholesale industrial unrest.
Yes.
But I mean, those were different times, actually, but I suppose an analogous situation. But it's the EAT. Do we have a more modern case where there was wholesale, existential commercial suicide or disaster looming, and they were still held to be unable to find that there was the reason was commercial?
No, not to my knowledge,
Yeah.
my lord. But the principle is everywhere that.
Well, not as starkly as I've described it, and I forced you into a corner deliberately because I think that's the corner you're actually in, and hopefully you've accepted that it is as stark as that, as a matter of law, because if it's not, and it's a matter of finding, they can find what they want, then obviously people will pragmatically, and even tribunals may pragmatically find that, I mean, none of these respondents are said by you to be bad people. They were protecting themselves, and that's the same in the facts of Din and the facts of the other cases, Amnesty and so on. They weren't bad people, and that's not part of your case at all.
No.
You just say, as a matter of law, they could not do what they did, and therefore they're liable.
Yes, exactly. There's a direct discrimination draws bright lines.
I was going to say Bob's your uncle, but I was wondering whether it was a politically appropriate phrase in the modern world. Maybe it should be Roberta's your aunt.
I certainly wouldn't know. But I should say that there is one further passage in Din at 92 which finishes the point.
Yes.
And where Mr. Justice Brown Wilkinson says what the finding will be if the facts are found a particular way.
Where in 92?
Letter C.
C.
B.
C.
C, thank you. Yes, I see that.
And it is at this point, in light of, my lord, your question earlier about other cases, that I should take you to the summary in Higgs in the Employment Appeal Tribunal by Mrs. Justice Evie.
Mm-hmm.
It's paragraph 58 of that report. It is also cited in my skeleton argument, if that is easier, at paragraph 16.
Now let's look at it in the judgment. 58.
Paragraph 58.
Yes. Okay, well, that's very clear, but it doesn't quite answer the question I'm asking, which is the finding of fact compelled by law?
No, I'm afraid I haven't put before you the Centrum case on the 5th line down. European case about a Belgian company where the director had said that he wouldn't employ immigrants because customers wouldn't like it or didn't like it. And that was held by the European Court of Justice to be directly discriminatory.
Well, I mean, obviously.
Yes. Yes. And our position, of course, is that this case is perhaps not quite as obvious, but not far short of it. That what the theatre and the agent wanted to do was not have someone with the claimant's beliefs on their payroll, on their books. And it's obvious what motivated them, or that her beliefs were part of the motivation. And the answer may be thought hard, but that is the answer. They either have a defence or they don't. But it is direct discrimination. And for whatever reason, the tribunal and the Employment Appeal Tribunal went elsewhere, treating that conclusion that it was commercial risk, simpliciter, as though it were the only finding.
And you say these cases show that you can't do that?
Yes. And to start with, that Lord Justice Bean didn't grapple with that at all.
I sometimes wonder why difficult cases come before me, Mr. Petto, but maybe there's an obvious answer.
I don't pretend it is anything else.
No, that's it. Yeah.
And my Lord, ground 2 is similar. The way Lord Justice Bean dealt with ground 2, I should set it up. The grounds at page 16 of the PTA bundle. This is the motivated by third-party discriminatory reactions point.
Well, it's the same point.
It's the point I've already addressed at some length.
I mean, you only got over the line by a whisker or something on that, but if you got over the line.
My Lord, you're referring to our exchanges earlier?
No, the getting over the line in the ET, where they held the fact
that we scraped over.
You crept over the line that there had been. I can't remember what it was.
Yes, my Lord, forgive me. It was a different point. That was whether the beliefs qualified for protection.
Exactly.
Yes.
So,
No, this is a different matter. This is that because the respondents were motivated by how other people did or would react to the claimant's protected beliefs, they were motivated by her beliefs.
But it really is the same point, isn't it?
As I was raising earlier.
Ground 1, the way you put ground 1, it comes to the same.
Yes, they overlap considerably. I'd certainly accept that.
I think it's the same. What did Lord Justice Bean say about ground 2?
page 3, my lord, if you're...
Yeah. Relying on the separability case.
Yes. Yes. And what Kong does merely is state the principle. There's no assistance.
Approach, not legal principle.
Yes. It gives it. Yes. It states the approach. Yes. It sets out the approach and gives guidance as to dealing with separability.
But in doing so, certainly in commenting on it in Higgs, it confirms that this is a matter of fact finding, not legal analysis. Hence the concerns about labelling it as if it were a legal principle.
Yes. Yes. And as I say, my submissions all derive from factual findings made.
Yes, I think we understand that. Is there anything more particular to this ground that we haven't?
No, I should say this. I hope it shan't be said against me that Kong somehow helps decide this case. It provides guidance on separability, but in my submission it goes no further than that. And that is why I say Lord Justice Bean failed to grapple with ground 2 along with ground 1, because all that is being said there, rather than addressing my submission about what I've described as the principle enunciated by Mrs. Justice Eadie in Higgs and then by Lord Justice Underhill, the passages I took you to earlier, but it is discriminatory to treat someone less favourably because of how a third party is discriminating or responding in a discriminatory way to their protected characteristic. And that's not addressed at all. And it's not addressed at all despite the fact that Lord Justice Bean agreed with that judgment of Lord Justice Underhill in Higgs. And that feeds through into the costs ground, the relevant cost ground in ground 6, which I don't think I need to take you specifically, simply to say that what the tribunal found and the finding that is challenged, and it is of course of enormous importance to the appellant, was that those arguments had no reasonable prospect of success. And in my submission, that is plainly wrong. Whatever the rights and wrongs may ultimately be, these are points that have reasonable prospects. These are reasonably arguable points. On the findings as made, of course the tribunal made its decision based on the evidence. So it relates to the claimant running these arguments before any finding was even made.
Can you, the cost judgment is quite detailed and covers a number of different issues. Can you just point us to the part where the Employment Tribunal says that this argument had no real prospect of success?
It's (34 and 35), paragraphs 34 and 35. 187.
Thank you.
I should have said 33 as well.
Yeah. Thank you. Okay.
And I think you have the points. I don't need to develop further what I've put in the skeleton argument. That
No. No, I think that's extremely helpful. I mean, obviously, Mr. Quintavalle wants to address what the contract point and so on, but for my part, I would very much like to hear the respondents on these main points, because obviously that's what the case is really about. So, how do you want to deal with that?
Well, my lord, I will very quickly take instructions. I don't know what, obviously, the respondents will need to work out where they stand as well. My lord, we have no objection to interposing the respondents.
And if we run out of time, we can take the harassment and contractual points and other points from the writing because they're very clear. You're happy with that, Mr. Quintavalle?
My lord, I wasn't planning to address the court on the contract and harassment points. I was planning to address the court on the so-called documents appeal, which raises totally separate matters regarding important matters, we say, regarding the jurisdiction of the court to make what in the circumstances amounts to a final injunction against the claimant in this case. So it's a very separate issue.
Yeah, very
I'm happy
separate.
to deal with it later, but I would like to make a few points, I hope, before the day's over.
Well, I think you'd better make those points now because it's going to get ahead of us otherwise.
I'm grateful. The reasons that Lord Justice Dean gave for dismissing the so-called documents appeal are in 3 short sentences, and that's up on page 3 where we see his order. And essentially he says that the documents appeal does not raise any issue of principle, and he frames the issue as follows in his final sentence of that paragraph. And he says this: "It is not arguable, in my view, that a party to whom a bundle of documents is disclosed has an absolute right to publish the whole bundle to the world." We say that this was not the issue before the court, and the learned judge's framing of the issue mischaracterizes both the factual situation and the central legal situation, and as such, there is a clear failure to grapple with the grounds that were clearly laid out in the permission to appeal skeleton. Firstly, factually, the appeal only concerned documents which were referred to in court and which had already been published to the whole world by order of the court. And this isn't a right, this isn't a case about implied undertakings, and it doesn't concern those documents which weren't referred to or read out to in open court. But the point that they had already been published to the world is also very important. What this case is about, and the mistake that starts, or rather what the case isn't about, we can also consider, the mistake starts in the Employment Tribunal, where the employment judge applies the dring jurisdiction in order to analyse whether the document should be allowed to remain on the website. The dring jurisdiction, and the mistake is, and that's the basis upon which the Employment Appeal Tribunal upheld the jurisdictional basis of the order which the employment judge made. And that jurisdictional basis, based on the inherent jurisdiction identified in dring, but also exercised through Rule 29 of the Employment Tribunal rules, is not one which could, in the circumstances, have been properly exercised, we say. And what the issue is about, what dring was about whether third parties could have access to documents which had been disclosed within proceedings, whether or not they'd been read out to or referred to in open court. And this simply isn't the case about third parties seeking access to documents. This is a case about one of the parties themselves saying that they've got a right to do what they wish for with the documents that have already been referred to or read out in open court. And the key case is the case of Harman and the Home Office. And domestically, Harman and the Home Office established, the House of Lords decided in a 3-2 decision, that there wasn't a right of a party to disclose documents which had been read out to. And in those days, the practice was to read every word of the witness statements out in court. But even though these documents had been read out in open court, the Judicial Committee of the House of Lords held that there wasn't a right of the parties to use those documents as they saw fit. However, this case then went to Strasbourg, and before the case was concluded, a settlement was made between the United Kingdom and Ms. Harman. And under the terms of the settlement, the United Kingdom agreed to bring in legislation which would permit parties, not third parties, the parties themselves, to make whatever use they wished of documents which were referred to or used in open court. And as far as the civil litigation is concerned, the way that this legislation was implemented was by Rule 31.22 of the Civil Procedure Rules, which confers that permission on parties to make use of the documents which have been revealed or referred to in open court.
Can I just pause you there, Mr. Quintarelli? Yes, indeed, that's what 31.22 provides, but it also contemplates that the court can make an order to the contrary.
Yes.
An order that is, in my experience at least, is quite frequently made for one reason or another.
That may indeed be the case, but the important point here is that, and this is where, this is certainly the position that the Employment Appeal Tribunal then adopted and pointed out, that Rule 31.22 does not apply in its entirety to Employment Tribunal proceedings, that Parliament has established a different regime, quite deliberately so, for the Employment Tribunal. It has its own sets of rules. The rule which does apply, and we see that from the case of IG Index, PLC and Cloty, where the court there, Court of Appeal there identifies that what is common to the Employment Tribunal and to civil and to litigation conducted under the Civil Procedure Rules is that which applies to implied undertakings. So what isn't the case is that one can say we have an implied undertaking and therefore this document can't be used. The equivalent of Rule 31.22 sub 2, which is the one where the court retains the power to restrict the use of documents which have been disclosed or even read out to by the court, and this is we say this is the important jurisdiction, that power has to be found in Rule 50 of the Employment Tribunal rules. It's not found in Rule 29, and it can't be. And this is a central point in the document's appeal, because it's very clear, and this was accepted, it's been accepted by all the parties, it was accepted by the Employment Appeal Tribunal expressly, that the source that the Employment Tribunal power invoked in order to, or exercised in order to restrict the subsequent use of documents which had already been published to the world, was Rule 29. And Rule 29 is a general case management rule, and it's there in the bundle, but the important point is this. Parliament has provided a very specific scheme under Rule 50, which lays out the considerations which the tribunal will apply when it's deciding whether to restrict the use of documents, to make any sort of orders restricting what can be reported or whether people's names can be given. And the very general case management rules under Rule 29 can't displace, in the circumstances, those particular rules. And in particular, they can't do so. And we say this isn't a case, it is a case which involves the open justice imperative. But it simply isn't a case merely about case management decisions. It's become a case once the matter has been published to the world, and once we see that the terms of the settlement agreement in the Harman case, this is an Article 10 case, and Article 10 requires that any rules that restrict the use, any restriction on freedom of speech has to be prescribed by law. Rule 50 of the Employment Tribunal rules, now Rule 49, satisfies that. There's no objections. It clearly lays out the considerations and the powers which the Employment Tribunal has. The vague in these circumstances and very general rules under Rule 29 simply couldn't provide the necessary jurisdiction for the court to do that.
So you say, as I understand it, the error was relying on Rule 29. The only proper rule is Rule 50?
Yes.
And that is engaged, even though it appears to be more about reporting proceedings.
Well, if we have a look at Rule 50, which is
Page 43.
ungrateful,
44.
we'll see that tribunal may, at any stage of the proceedings on its own initiative or on application, make an order with a view to preventing or restricting the public disclosure of any aspect of those proceedings, so far as it considers it necessary in the interest of justice, or in order to protect the convention rights of any person. So that power is the power which should have been exercised, subject then to the sort of considerations which would have had to be invoked. The dring jurisdiction, which was instead the jurisdiction which the employment judge purported to exercise, was totally misplaced. This dring relates to third-party access to documents which have been disclosed in appeal. It's simply the wrong jurisdiction, we say, on however it's looked at. And as far as the inherent jurisdiction of the court is concerned, we refer in the Skeleton argument, we cite paragraph 18 of the Supreme Court case of Pujan Times newspapers, where that makes it very clear that there isn't an inherent power of the court at common law to impose those sort of restrictions on materials which have been read out to an open court. So it's important that the court does retain the power to restrict, in appropriate circumstances, the use of documents, but that has to be a power in this particular case exercised under Rule 50. And the second part of our concern was that it's very relevant, the fact that by court order itself, these documents had already been published to the world. So in these circumstances, those were the issues which the court needed to grapple with. Those were the issues which Lord Justice Bean needed to grapple with. And we say that instead he dealt with completely the wrong question and didn't deal with these issues which were clearly set out in our grounds of appeal. And I should say, and this goes to the importance of the matter, because it can be seen as a somewhat peripheral matter which doesn't have particular bearing on what might be seen as the more important issues which this case raises. But for the claimant, these are very, very important issues. As the evidence in the court below showed, she was, as a result of the furore which arose surrounding this case, she was subject to death threats. She had her career and reputation destroyed, and she feels she's not now able properly to tell her side of the story by showing what the parties had in fact said in court. So to her, it is an important part of this appeal. And finally, there isn't anything else she can do about it, because what the employment judge said in paragraph 22 of her further reasons on this, and this was then endorsed by the Employment Appeal Tribunal as well, the time has passed now for making applications to be able to access these documents. You had 14 days to do it. That's the end of the matter. So this isn't a case, as in other injunctions, where there's liberty to apply for the parties and be able to seek to discharge them. This is a situation where she's precluded, if this matter, if the decision stands, from ever being able to make use of these documents again. For that reason, say this is an important matter. The claimant doesn't have any alternative remedy, and there was a clear failure to grapple with the central issues in the case. I'm having made those points, I'm content for the court to rely on what's said in the Permission to Appeal skeleton, because it was laid out, and it's unfortunately this important jurisdictional point wasn't grappled with in the Permission to Appeal application.
Thank you very much, Mr. Contabale. Good. Who's going first? Mr. Coughlin.
My lords, my lady. Before I grapple with the substance of my learned friend's points on grounds 1 and 2, may I just draw the court's attention to my lord's decision in the BHP case, which sets out the nature of the court's inquiry at the Rule 52 30 stage. So the court will find that in page 924 of the authorities bundle.
Yes.
And it's the highlighted passage.
Yes.
And my lord, I hope will forgive me for reminding your lordship of your lordship's own judgment. But paragraph 57 sets out the nature, or sets out what the test is. Starting point that determinations of appeals will not be reopened unless, number one, it is necessary to do so in order to avoid real injustice, and the circumstances are exceptional and make it appropriate to reopen the appeal. And that applies equally to the determination of an application for permission to appeal. And then through a review of a number of authorities deriving from this court, my lord identifies a number of key principles which emerge from those authorities and indeed from that test at paragraphs 59 through to 60. And I would just highlight a series of them. Firstly, the need for exceptional circumstances, which is flagged up not only in the wording of the rule, but in paragraph 59 of my lord's judgment, citing Taylor and Lawrence at page 10, the circumstances must be, quotes, truly exceptional. Secondly, it must be shown that the integrity of the earlier litigation process was critically undermined. We see that from, amongst other places, that first paragraph of Taylor and Lawrence.
I think it's Goring, actually.
Forgive me, I'm grateful, my lady. This is the summary of the principles taken in Goring. Thirdly, if it could be shown, and this is paragraph 13 of Goring, citing Guy, if it could be shown that the judge had completely failed to understand a clearly articulated point, it is possible that his decision might be susceptible to being reopened, particularly if the facts were as extreme in their nature as a judge failing to read the right papers for the case and never realising it. And that's a reflection of the fact that, as we see at paragraph 14 of Goring, the paradigm case is fraud, bias, of course those aren't alleged, or whether judge read the wrong papers. The court will see that at letters C to D of this passage. And then a little further down at D, the broad principle is that for an appeal to be reopened, the injustice that will be perpetrated if the appeal is not reopened must be so grave as to overbear the pressing claim of finality in litigation. It is not enough to show that the decision to refuse permission to appeal was wrong. And we see that from the end of paragraph 14 in Goring. That in itself is not enough to displace the fundamental public importance in finality. And even if the process has been vitiated, the court must also be satisfied that there's a powerful probability that the decision was wrong. And the court will see that at paragraph 15 of Goring, cited at the end of paragraph 59 of BHP. And I would also just take the court, if I may, to Goring for two final points. So that's at page 525, please. And it's the point made at paragraph 28. Top of that page, just below A, the reasons given for refusal of permission to appeal on paper will normally be short, will not generally be vulnerable to criticism simply on the ground they do not deal expressly with every argument put forward on behalf of the applicant. The essential task of the Lord or Lady Justice dealing with an application on paper was to make clear that the main arguments identified in the applicant's grounds of appeal had been addressed. And finally, paragraph 30 and 32 of Goring, the point is made that the principles which have been identified apply with equal force, both to applications to reopen substantive appeals and also to applications to reopen applications for permission to appeal, and equally to cases where permission has been refused on papers. And so the claimant has recognised the height of that bar, and the way that was reflected was in the way in which an application was made for Lord Justice Bean to recuse himself. And I set this out in my skeleton argument at paragraph 16. But this is a quote from the claimant's application for that recusal. The application goes much further, as it must, than saying that Lord Justice Bean made an error of law. An unfortunate necessary implication of that submission is that Lord Justice Bean has failed in his judicial duty, and the merits of that criticism are crucial to the outcome of the application for permission to reopen the appeal. So that is the framework within which I'd invite the court to approach this application to reopen a closed appeal. What I'd next like to do is to highlight briefly three relevant aspects of the litigation as they've arisen. Firstly, the staleness of the litigation and the importance of finality. Secondly, the fact that this is now the fifth bite of the cherry for the claimant. And thirdly, that which is alleged in relation to Lord Justice Bean's decision is by necessary implication, equally being alleged in relation to Mrs. Justice Eadie's decision. So dealing with those in turn, firstly, the importance of finality in this case. This is a case where the facts date back to March 2019, so 7 years now. And the case was heard at the very start of 2021, so 5 years ago. If the case were to be remitted, and if the claimant were to succeed in a substantive appeal, it would have to be, then, given the state of the lists, we would be looking at a rehearing before a different employment judge, because the employment judge has retired, subsequent to the case being closed with Lord Justice Bean's decision. We'd be looking at a rehearing in 2029, probably. And those matters underline the importance of finality in this case. Secondly, this is indeed the fifth bite of the cherry for the claimant in this case. The case having been heard, considered by specialist judges at 4 stages of the judicial hierarchy. Specialised full Employment Tribunal, the President of the Employment Appeal Tribunal, who dismissed the claimant's appeals in the course of a 76-page judgment after a 3-day appeal hearing. Lord Justice Bean, who considered each of the claimant's grounds of appeal and gave reasons for refusing each of them. And the European Court of Human Rights, which I'll invite Mr. Milson to address. I anticipate that I'll adopt all of his submissions, having seen them in writing. That is my position. But this is now the fifth attempt by the claimant to argue the case. And the third overarching introductory point I make about the state of the litigation is that what the claimant essentially says, in order to show the exceptional circumstances needed and the vitiation of the litigation process, is that by reaching decisions in this case and then in Higgs a few months apart, which resulted ultimately in different conclusions, it can only be the case that Lord Justice Bean has failed to understand.
Well, can we take some of the heat out of this, Mr. Coughlin? I think Mr. Fetto has put this case in a very modest way. And for my part, I would rather deal with it in a modest way without casting aspersions left, right and centre at judges in this court and below. The question for this court, the first question, is whether he is right about the law, and that is that it is not open to a court or tribunal to decide in circumstances like these that there has not been discrimination. You've heard all the discussions, so we don't need to repeat the argument. Now, that seems to me to be at least a perfectly proper argument to bring forward and needs to be dealt with. So for my part, it would be most helpful if you were to deal head-on with that and tell us what your submissions are, and then we can come to all the paraphernalia of 5230, which I think you understand, we understand
Of course.
full well. We are not, for the avoidance of doubt, in the business of reopening decisions of this court, not only save in the most exceptional circumstances, but save where 5230 is satisfied, if I can put it in the colloquial language, in spades. So we will expect to see that. But if Mr. Fetto and Mr. Quintavalle were right, that this is the legal position, clearly, not even clearly if it's really arguable, the legal position, and then that at least gets them to base 1. And if not, it doesn't. So it would be nice to hear your submissions.
Of course.
I suspect your submissions are that it doesn't, is not even arguable.
That it's not even arguable that Lord Justice Bean was correct.
Yes,
and
I
that
get
Lord
you're
Justice
going to say that, but I want to hear why.
and that Lord Justice Bean engaged with the argument fully.
Yes, well,
So-
in a sense, I mean, Lord Justice Bean dealt with it in the completely ordinary way, if you're right, but not if he's right. So let's see what your submissions are about that.
Yes.
Sorry to cut off
No, of course.
the histrionics, but this is quite important if he's right. It has repercussions, and he's put forward, as I say, a modestly argued and interesting argument based on some cases that are decided by very senior judges.
Indeed so, my
Or
lord.
those that became very senior, actually.
Indeed so, my lord. But I think it is nevertheless right for me to point out that the basis on which the application has been advanced is an impossible
That doesn't mean it has to
inconsistency.
succeed on that basis.
No, but nevertheless, that's the position until this morning that has been taken.
That often happens. I don't know why.
Um,
That's a sort of function of litigation.
Of course.
People take points that are far too strong, but sometimes succeed on points that are weaker.
Yes. So let me deal then with ground 1 first of all.
Yes, marvellous.
So this is the reason and motive ground. And the tribunal, we say, made findings of fact that the second respondent did not dismiss the claimant because of her beliefs or because of the manifestations of her beliefs in her Facebook post, but because of matters separate from that. Namely, the dysfunctional situation which had arisen and the commercial reality that with the claimant in the cast, the production would not succeed. And my lord has already taken my learned friend to paragraph 107, where those findings are made. And we say those are indeed findings of fact.
Yeah, I mean, I think you understand the point. The point is that's not open to them because it is beyond doubt that the dysfunctional situation, the commercial reality, arose because of her beliefs, retweeted and then confirmed in a statement, and would not otherwise have arisen, like the racial discrimination in DIN, if that's the case, correct name. And what he said is, it matters not that a commercial, a completely intractable commercial situation arose because of that. By dismissing her, it was not open to the tribunal to say that the discrimination against her beliefs was not a step on the way.
Yes.
Yeah.
And there are a number of stages to the answer to that. The first is, this is a question about the reason for the treatment. And that is a question of fact, which is a point made by Mrs. Justice Eadie, and it is the decision, the basis for the decision of Lord Justice Bean. And of course, grounds 1 and 2 do flow together very much.
The same, I think.
They become, the more one looks at them, the more they resolve into a single point. And so, if I can invite the court to turn
I
to...
mean, the question is a logical question. All the cases they refer to are cases where the respondents were good people, I can put it this way, and no desire to discriminate or do bad things. but somebody else was, for the want of a better word, a bad person. Somebody else, a third party, was discriminatory, prejudiced, and was hell-bent on making trouble for the good respondent if they allowed the situation to continue, and therefore they took what was only open to them commercially, the step that was only open to them commercially, which was to get rid of the person who was being discriminated against, and that was held to be unlawful. Now, it seems to me anyway at first sight, having heard Mr. Fette's very persuasive argument, that has some possible merit. So why doesn't it?
Well, the very shortest answer to that,
Yes,
my lord,
that's what I want before lunch.
Before
I can
lunch.
go away and think about it.
the very shortest answer to that is it's the combination of the two reasons given by Lord Justice Bean, particularly on ground 2.
Okay, can we just
So-
look at it then?
So it's the permission to reopen the appeal bundle at page 3. The reason why, so ground 1, the reason why issue is a question of fact. Referring to and adopting the,
Which paragraph of
this is
Lady
paragraph
Justice?
1.
What, of Lady Justice Simler?
No, I'm Lady Justice Simler, that's paragraph 50. Let me just find the reference for you.
It's tab 43,
It's tab 48, I believe.
page.
Yep.
Well, I've got it at tab 43.
And it's page 992.
996.
992.
Oh, you're quite right. It's common page. Sorry. Okay, so Lady Justice Simler was in both. Which paragraph? Of,
So it's paragraphs 52 through to 59, my lord.
of Con.
Con.
Sorry, so that's your second read. Your two short reasons. First, question of fact. Second,
First, it's a question of fact, and secondly, it is permissible that in an appropriate case, an employer can take action against, in this case it's a whistleblowing case, but the principle is the same, we say, who makes a protected disclosure in what's regarded as an unreasonable or acceptable manner, or who acts in an unacceptable way in relation to
So where are you reading this?
I beg your pardon?
Where are you reading what you're just
This
saying?
is paragraph 54
Of Con.
of Con, my lord.
An employer can take action against a worker who makes a protected disclosure in what is regarded as an unreasonable or unacceptable manner. Yes. Okay.
So,
Yeah.
in other words, this, well, I should say, this derives from and endorses the decision of this court in Fessett, which is summarised in the paragraph above at 53. And your lordships, your ladyship will see the summary of the facts given by Lady Justice Simler. Protected disclosures were made, and the same inquiry is made in a protected disclosure case as it is in a direct discrimination claim, namely what is the reason or what are the reasons operating for the decision. So a number of nurses made protected disclosures, which were found.
What was the protected disclosure, sorry?
I think that the colleague was claiming to be more qualified than he actually was. Is that your lordship's question?
Yeah.
I'm reading. I don't remember from the case itself, but that's Lady Justice Simler's summary of it at the start of paragraph 53. The colleague's employment continued. The whistleblowers, dissatisfied with this outcome, continued to press their concerns. Grievances and counter-grievances from others were pursued. The NHS Trust ultimately concluded, so pausing there, we have people on both sides who are expressing their views, as both may be entitled to do. The NHS Trust ultimately concluded that the only feasible way of resolving the workplace conflict was to redeploy 2 of the whistleblowers and remove the 3rd. The tribunal criticised the management response to the situation, but concluded nonetheless that the reason for moving the nurse claimants was not the making of the protected disclosures, but the dysfunctional workplace situation that could not feasibly be resolved without moving the whistleblowers. And so what the tribunal was found to have done permissibly was to identify the resolution of a dysfunctional situation as being the reason, not the motivation, but not the motive, but the reason for the treatment. And what the protected disclosures did was to form the context for that reason, but not the reason itself. So fundamental distinction, we say, between context and reason.
So what you need to help us with after lunch is the interaction between the principles explained, separability principle explained in Kong, and the cases like Din and Amnesty, which seem to adopt a much starker approach. So perhaps you can think about that, and I promise to read those passages in Kong carefully over lunch and return.
Thank you, my lord.
My lord, could I add to the reading on this point, because it saves me having to turn to it this
You
afternoon.
might be pushing your luck, Mr. Nelson.
I'll try and
Right.
do what you like with it, my lord. But it's page 418 of Fessett, paras 50 to 53.
Yes, it Paris.
50 to 53, my lord.
Thank you.
Judgment of Lord Justice Elias on similar and square on point.
Doesn't sound too long, so
It's half a page.
I'll accept the homework. Thank
Great.
you. 2 o'clock.
All rise at table.